The Family and Medical Leave Act, FMLA, is a federal labor law dating back to 1993, offering eligible employees the right to take unpaid, protected leave for family and medical reasons while maintaining their group health insurance. Its core aim is to help individuals strike a balance between work and family life. Essentially, FMLA provides up to 12 weeks of unpaid leave per calendar year for eligible employees without jeopardizing their job security. It mandates employers to uphold health benefits as if the employee were actively working, ensuring a smooth return to work without fear of demotion or termination. Eligible circumstances for this leave includes various family-related situations such as childbirth, caring for a newborn, looking after a family member with a serious health condition, or handling a personal medical condition that hinders job performance. FMLA's existence is to afford families the necessary space to care for their loved ones without the anxiety of job insecurity. The scope of FMLA extends to critical situations such as caring for immediate family members with serious medical conditions, pregnancy, the placement or fostering of a child, and the care of injured service members. Additional provisions cover care for service members in the armed forces, encompassing various scenarios from medical treatment to temporary disability. To determine eligibility of FMLA, individuals should engage with their employer, HR department, or refer to state laws. An in-depth exploration of FMLA eligibility and comprehensive resource list to aid in the process can be found in our article on FMLA. Each state has its own unique take on Family and Medical Leave Act regulations, building upon the federal standards to offer additional protections or guidelines for workers. States like Illinois, California, Florida, Massachusetts, and Texas all share the same eligibility requirement under the FMLA of 12 months of work history, amounting to at least 1,250 hours. Let's look into it more closely. The FMLA regulations in Illinois closely resemble federal standards but come with added provisions that particularly favor employees. It encompasses a range of scenarios such as personal health concerns, family caregiving, childbirth, and military-related leave. Notably, starting January 1st, 2024, the state mandates paid leave for all employees regardless of employer size, emphasizing the inclusivity of accrued paid leave and flexible usage. The Illinois Paid Leave Act for all workers is predicted to foster positive economic and social impacts by enhancing employee well-being, reducing turnover, and boosting productivity. Now, California's version of FMLA ensures vital protections, providing eligible employees with up to 12 weeks of unpaid leave annually for personal health needs or family care. The California Family Rights Act complements these provisions, tailoring them to the local context. Employers with 50 or more employees within a 75-mile radius must comply. These acts guarantee job reinstatement, maintaining health benefits during leave, and cover reasons such as childbirth, family personal health conditions, and cases linked to a family member's military service. In Florida, the FMLA ensures state employees receive up to 12 weeks of unpaid job-protected leave annually for various personal and family health needs. Covered circumstances encompass personal health conditions, childbirth, family care, and military excision. The FMLA secures job reinstatement, continues health insurance, and allows for the use of accrued leave or disability benefits. Returning employees are guaranteed their previous or equivalent positions without any negative impact on their status. Massachusetts FMLA also offers up to 12 weeks of job-protected leave for personal or family health needs, childbirth, adoption, and military service. Alongside the paid family and medical leave program, reasons for leave encompass health issues, family care, and military reasons. Employees maintain the right to return to their roles post-leave with continued health coverage. In Texas, FMLA provides unpaid leave for personal or family needs, childbirth, adoption, or military service. Employees receive 12 weeks of leave or 26 for military caregiver leave, ensuring job security and benefit maintenance upon return. Employers must comply or refrain from retaliatory actions. Requests necessitate prompt communication and may require medical documentation with accrued paid leave usable alongside FMLA. If an employer violates an employee's FMLA rights, there are steps they can take to address the issue. Initially, resolving the matter internally by discussing it with HR or a supervisor might help clear misunderstandings. Keeping thorough documentation of leave requests and any employer actions that seem to breach FMLA rights is crucial. Seeking guidance from an employment law attorney can offer clarity on rights and options. Employees can file a complaint with the Department of Labor, which investigates FMLA violations and mediates disputes. Complaints must typically be filed within 2 years or 3 if a violation was willful. Additionally, the employee may opt for a private lawsuit with a similar time frame. Remedies for violations can include back pay, reinstatement, promotions, or compensation, which might cover attorneys' fees. It's important to note that the FMLA prohibits any form of retaliation against an employee for exercising their rights, such as filing a complaint or a lawsuit. If you found this video helpful, consider giving us a like and comment below to share with us what you think. And as always, subscribe to our channel for more HR topics and tips. Thanks for watching, and see you next time.